interrogation control person, Mr. Becker, videotapes are subject to too much scrutiny in court. We don't want the LEA people, law enforcement authority people, in aggressive sessions anyway. Lieutenant Colonel Beaver, law enforcement authority choose not to participate in these type of choice not to participate in these type of interrogations is more ethical and moral as opposed to legal. And then this line from Mr. Fredman: the videotaping of even totally legal techniques will look ugly. Now, that phrase is particularly troubling to me because inherent is that phrase that videotaping even the totally legal ones would look bad. For God's sakes, let's don't tape the ones that are illegal.
For people who have never participated in a police interrogation, I would just say that it would make anyone uncomfortable. And so without a context, without understanding the situation, I'm not trying to be in Mr. Fredman's mind. I'm saying I understand probably what he is saying is that even when you have a legal police custodial interrogation, that people can be uncomfortable. I would just say videotaping is not necessary unless your military intelligence people need it for whatever purpose, because we had closed circuit TVs where the people could watch the interrogations 24/7. And so it wasn't necessary to videotape unless there was an intelligence purpose. So my only point is that even when, yes, I mean, again, if you've never witnessed a police interrogation for hours and hours, when you're interviewing a suspect, it can be very uncomfortable. It's not
I will tell you, Lieutenant Colonel Beaver, I have witnessed.
Well, I'm not saying you personally.
I must object to this line of questioning, ma'am, with all due respect, Senator.
Excuse me.
Mr. Chairman.
Excuse me.
Yes,
Can you, first of all, identify yourself?
Yes, Mr. Chairman. I'm Lieutenant Colonel James Friend. I'm the defense counsel for Lieutenant Colonel retired Beaver. My objection, sir, if I may.
Can you speak up? We can't hear you.
Yeah, I'll tell you what. If you're, can you consult with your client there, and then either you or her speak into the microphone, one or the other?
Else.
You want to speak into the microphone?
I would like to object to my client being asked about what someone else said and the inferences it's attributed to her. I think that's an unfair question.
All right. Let me just.
I'll be happy to straighten the record out.
Your objection is noted. Okay.
Yeah, I was asking you, Lieutenant Colonel Beaver, if these things were said in front of you in your capacity as the staff judge advocate, if you recall, these were notes taken by Criminal Investigative Task Force within DOD, contemporaneous with this meeting, attributing some statements to you and some statements to Mr. Fredman. I was asking, do you recall those statements being made? I was not saying, I think I was very clear that Mr. Fredman said this, not Lieutenant Colonel Beaver. Do you recall those statements being made in front of you in your capacity as the judge advocate, staff judge advocate at Guantanamo Bay?
Ma'am, the meeting was for non-attribution purposes so that people could speak their minds and that opinions not be held against someone in an adverse way. It was a brainstorming session. People spoke up and had different opinions. I don't recall what was said 6 years ago, but the purpose of the session was to allow people to speak freely and address their concerns, whether it be the law enforcement community, the intel community, the lawyers, the military police, and so that we would get a genuine discussion of the issues. And so if you you restrict what can be said, then you're going to have people doing things perhaps in darkness, and you won't know about it. So I wanted people to have a good collegial discussion, and as I recall, we had a good collegial discussion, but I cannot recall precisely what was said by a particular person or whether, law enforcement, and the law enforcement people were particularly hostile towards me and were very unhappy with me that I was even having these conversations. But I still thought it was best to do it in the light of day and include everyone than to just limit it to military intelligence personnel. But I'm sorry, I cannot recall with any certainty what was said 6 years ago.
Well, I think it's important that the law enforcement personnel were included in these meetings, and I'm sure they have witnessed as I have, many, many, many interrogations, and I'm sure that's why they thought it was important to take notes. And let me close my questioning by reading into the record, Mr. Chairman, what one of those law enforcement task force, the deputy commander of the Criminal Investigation Task Force, said in an email within a month of this meeting, in looking at the notes from the meeting. This looks like the kind of stuff congressional hearings are made of. Quotes from Lieutenant Colonel Beaver regarding things that are not being reported give the appearance of impropriety. Other comments like, quote, it's basically subject to perception. If the detainee dies, you're doing it wrong, end of quote. And quote, any of the techniques that lie on the harshest end of the spectrum must be performed by a highly trained individual. Medical personnel should be present to treat any possible accidents, end of quote. Seem to stretch beyond the bounds of legal propriety. Talk of, quote, wet towel treatment, end of quote, which results in the lymphatic gland reacting as if you are suffocating, would, in my opinion, shock the conscience of any legal body looking at using the results of the interrogations or possibly even the interrogators. Someone needs to be considering how history will look back at this.
Chairman, I just please one comment. I invited the Criminal Investigative Task Force, law enforcement, if they had concerns, to put them in writing and put them through to General Miller so that they could be considered. They did not. I also said if they had any concerns about violations of the law, that was never, not a single FBI agent or CITF and task force person ever, except on one occasion where they said Dave Becker put tape on a detainee's mouth, ever came to me and said there's a violation of the law. They had policy arguments and ethical arguments, but they never came to me and said, right now, there's something going on. I think it's a violation of the law. This has all been years later through emails and hearsay. And so if they felt that way at the time, they could have given me the same courtesy that I gave them.
I couldn't agree with you more.
It did not happen. They went to Mr. Mora. That's fine. I didn't know about that. But at the time, I would have looked at anything seriously, and they knew that.
I couldn't agree with you more. And that's why I called Mr. Mora a hero. Thank you, Mr. Chairman.
Thank you. The, what tab is this? If you could look at tab 11, Colonel Beaver, I think you'll find there a letter from the Criminal Investigation Task Force giving an assessment of the JTF 170 counter-resistance strategies.
It was never shared with me, Chairman.
But they shared it in writing. You didn't mean to imply that they never put in writing their objections, did you?
In terms of meetings I had and discussions I had, they did not provide me anything in writing with specific interrogation techniques or that nature. I understood that they were discussing it with the Army Office of the General Counsel, and also I didn't know Mr. Mora, but I knew higher headquarters. And I was told by an attorney at the Office of the Army General Counsel that their objections were policy-based and not legal-based. But I never...
Well, let me read you this from that, if you could take a look at that exhibit.
Sure.
CITF personnel who are aware of the use or abuse of certain techniques may be exposed to liability under the UCMJ. It sounds legal to me. This is what they provided to the Secretary of Defense. This is what they provided to Admiral Dalton. Admiral Dalton said she saw this. I mean, this is
I never saw it.
but you're not, I know you didn't see it. I'm not asking you if you saw it. I'm saying you didn't mean to imply in your testimony that they never set out their objections to what you were recommending in writing. It's just that you say you never saw them. Is that correct?
We lived and worked together there, and I'm just saying they didn't afford me the same opportunity that I afforded them, which I gave them.
I'm just asking you a very direct question. You're not suggesting that they didn't put their strong objections.
Sorry, sir.
I'm asking. You didn't mean to suggest that, did you? You just weren't aware of it.
Until today, this is the first time I've seen this memo.
That's fine.
Thank you.
It's just that you were not brought into that loop. You had already sent your opinion on. The Joint Chiefs had asked for an opinion in Washington. What do they think about your opinion? They then asked the services, what did they think? This is a response from one of the services as to what
Okay.
they thought of your opinion.
And this is after
Whether they should,
discussions.
it's after what?
No, sorry, I'm sorry, sir.
It's after
I thought
what?
you were done. No, this is after discussions that we had on the island.
It's dated November 4th,
Sure.
2002, which is a month to the day prior to the Secretary of Defense signing his memo. Is that
sir.
correct?
Uh-huh.
All right. Now, Colonel Beaver, after the Secretary of Defense approved the techniques on December 2nd, did you work with the senior staff at Gitmo to develop the standard operating procedure at tab 16? If you could take a look at tab 16.